the biggest story this morning, arguably, is what happened from the Court of Appeal yesterday with regard to Dr. Kessie Olato-Forson, who was charged with causing financial loss to the state, and Richard Jakpa, who was also charged with causing financial loss to the state. That trial had been going on because it was in 2023 that a prima facie was established against them. The submission of no case that they had applied for was thrown out. Prima facie was established by the judge, and they were asked to open their defense. And Richard Jakpa and Co. had already opened their defense. But they decided to appeal that submission of no case at the Court of Appeal. And yesterday, the Court of Appeal, as you may well know, and we've been reporting this since yesterday, we broke the news here when it happened. Mutala Inusa brought us all of those details. The Court of Appeal, with 3 judges sitting, said that Richard Jakpa and Dr. Kessie Olato-Forson don't have any case to answer. And the state has not been able to bring any concrete evidence which shows that they have a case to answer. And so they have been acquitted and discharged. Acquitted and discharged means that the case which is in the High Court, which has been going on essentially, has ended. And they are free men. They are no more any, subject of any court processes whatsoever. They are free to do whatever it is that they want to do. This is an acquittal and a discharge. This is not maybe just a discharge or something like that. Acquitted and discharged. So essentially, they are very free men. And that is what has happened. And the Attorney General has been reacting, and the Attorney General has used some very unprintable words to describe the ruling of the court, right? And I've even heard the Ghana Bar Association condemn what the Attorney General has said, or how the Attorney General described the ruling. Some very unprintable words. He first did that, and then there was subsequently a statement which was also issued, and the statement he sort of tamed down, or was a bit tame, but he still, described it in a manner which a lot of people felt was very unpalatable. You have the statement, IB?
Yes, I think I do. I have the statement here. So, a moment. That's the
okay. I also have the statement here. So let me just go through the statement. I thought you were going to go through the statement. So it says that on 30th, and this is a press release to all press houses, and it's the Republic versus 1, Kessie Olato-Forson and 2 others. On the 30th of July 2024, the Court of Appeal, by a split 2-1 decision, allowed an appeal against the ruling of the High Court in Accra dated March 30, 2023, dismissing a submission of no case filed by the accused person and ordering them to open their defense. The Office of the Attorney General considers the decision of the Court of Appeal to be perverse in the quest for public accountability and the rule of law. The decision clearly is heavily against the weight of cogent evidence led by the prosecution in a submission or in a substantiation of all the charges against the accused persons at the trial. The relevant facts of the matter as borne out of the undisputed evidence led so far show that vehicles purporting to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. The then Minister for Health, Ms. Shariaite, cautioned in writing against the importation of the vehicles into the country. There was thus no request by the Ministry of Health for the vehicles to be imported into the country or for the letters of credit which were the means of payment for the vehicles under the contract to be established. With no request from the Ministry of Health or any authorization whatsoever, and at a time that the period for supply of the ambulances under the contract had even elapsed, the first accused, Dr. Kessie Olato-Forson, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller and Accountant General to issue letters of credit for the payment of the vehicles. The letters of credit were consequently established on 18th August 2014. Big C General Trading LLC, the suppliers of the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract. Further, apart from the absence of basic parts and equipment required for an ambulance, the National Ambulance Service and the Ministry of Health noted serious defects with every material part of the vehicles. Such was the fundamental nature of the defects that a former Minister for Health, Dr. Alex Segbefia, described the vehicles as ordinary vans, not fit for purpose, in point to the fact a report on the vehicles by the authorized dealers in Mercedes-Benz commissioned by the Ministry of Health in 2015 to assess the vehicles, which is tendered in as evidence by the prosecution, stated that the vehicles could never be converted into ambulances. The defects were so irredeemable that from the time the vehicles started arriving in December 2014 up to January 2017, when the erstwhile John Mahama administration left office, they could not be converted into ambulances. The Office of the Attorney General considers the decision of the Court of Appeal grossly unfair to the nation and inimical to the fight against impunity and abuse of public office. The office will promptly file an appeal in order to erase the effect of this erroneous decision of the Court of Appeal. So this is signed by Godfred Dame, Godfred Yeboah Dame, Attorney General and Minister for Justice. So he says that, first of all, the decision of the Court of Appeal is perverse in the quest for public accountability and the rule of law. Exactly. And it goes on further to describe it as grossly unfair to the nation and inimical to the fight against impunity and the abuse of public office.
This statement is the only thing that ought to have emanated from Godfred Yeboah Dame. But typical of our politicians who will not consult communications people before they speak. What the statement you just read, as against the interview Godfred Dame granted.
Yeah.
The heat in this statement, if it's 20%, the interview and the heat is almost 200%.
Visibly very angry.
He never spoke like an AG in that interview. In fact, they say he didn't even speak like a lawyer. See, yesterday this played out in Parliament. Harun Iddrisu, a lawyer, former minority leader, expressed the excitement of his side over the decision and went further to say that this is testimony to the fact that there are still fair-minded people at the bench. And that is not everybody who could be controlled by the executive, everybody within the judiciary. And then said that he had heard that Godfred Dame was going to appeal. Well, it is his right, but he can only assure him that he's just furthering what he had reduced to describe as a disgrace. Right? And that he should just swallow his ego, and I'm quoting Harun Iddrisu, and let it go. Alexander Kwame Afenyomakin came in and then sounded a caution that, yes, you are happy. We are happy together with you that justice has prevailed. But that is the more reason why we shouldn't be bastardizing the judiciary. After this, and after hearing the AG, I said, oh, then admonishment from Alexander Kwame Afenyomakin can equally go to the AG, who is the leader of the bar.
By default.
Yes, we shouldn't be bastardizing the judiciary. And this can not only go to the NDC, it can equally go to the AG. Now, you understand why, and I've said this, that this case is more political than legal, because its political implications are much more.
Yeah.
You know where the conversation has gotten to now. Why didn't Dame take the 2 million euros from the suppliers?
Yeah.
The 2 million euros.
Yes,
which was offered.
Yeah,
but he has explained that.
Oh, no, there's no explaining this, my brother.
He has explained
See,
that we
was the
know that
offer
there's criminality
No.
involved.
No,
See,
no.
there's criminality involved.
See.
We need to prosecute
But
the case.
the ultimate
and
thing
deal
is,
with the criminality.
so
So
now,
now, how would it look? How
I'm
would it
coming.
look?
I'm
I mean,
coming.
if I know that there's criminality involved, and I go ahead and take 2 million.
Do you know we take plea
And then
bargaining for
leave,
Meda?
and then leave the
You
case.
know we take plea bargaining for Meda.
Yeah, you get it. So
Yeah,
all-
people get deals for Meda.
I'm
You know
talking
that,
about
right?
the explanation that has been
I get
given
you.
by the
I
explanation
understand
has
you
been
perfectly.
offered. Whether
I understand you.
whether
But the
it's
point I was
tangible
making
is
is that,
another
see,
issue.
the AG is within his right to go to the Supreme Court. But let's assume that the Supreme Court upholds the judgment from the Court of
So then
Appeal,
it ends the matter there.
then we've lost $2 million euros. That's the point I'm
But
making.
that's now we've already lost it anyway.
That's the point. So that's why I'm telling you that this is more political than it is legal, because the implications are there. Look at what played out at the High Court, the audios and what have you.
Yeah.
Look at the allegations and the counter allegations, right? So I understand Dami. Dami is fighting for his reputation.
Yeah.
See, the damage Dan Dami will push him to go to the very last end. Even if there is something called International Court of Arbitration, he will go.
Because of his reputation.
Exactly.
But you see,
Because his integrity has been impugned by Mr. Richard Jakpa,
Good.
especially with the leak of the audio.
but
and the circumstances under which that audio was even recorded. And people are talking about some misconduct that may have been conducted on the part of the Attorney General of the country, because you were heard on tape speaking to someone that you are prosecuting and telling the person to feign sickness, and do other things, so that the case can go in a particular direction or not. And you should not be seen as an Attorney General to be doing that. And there are many people who have called for there to be, an investigation, called on the General Legal Counsel and all the other stakeholders to do an investigation into Godfred Dami, and that has not happened.
Godfred Yeboah Dami is not just an Attorney General. He's also a Minister for Justice.
Yes.
You get it?
Yeah.
So there is a point. He needs to draw the line.
Yeah.
And look, who am I to even offer him an advice? I've
No,
been to
you
law school,
can.
But I only feel that look, if you are prosecuting on behalf of the people, you need to even look at the general sentiment.
Yeah.
Lantam, you are on social media. You are everywhere. You are in the media space. Well, from where you sit, what is the general sentiment?
The general sentiment is that this is unnecessary.
You get it.
It's unnecessary.
So once you are holding that power in trust, and the people seem not to be so interested in the line you are pursuing, it is just fair.
But what about the other side of the argument that if we believe that financial loss has been caused to the state and we do not prosecute and try and recover some of the monies or even punish the people who have caused financial loss to the state, then what are we doing?
As a nation,
what are we doing?
But the answer is here.
that is
here.
That is one.
Let me take
that.
you through the judgment.
Yeah.
Briefly. The answer is here. It says, further, the evidence establishes that the first appellant's approval was not sought by the BOG before payments were made, but rather the Ministry of Health. Mind you, Dr. Kesel Atoforsen, and before I read the judgment, let's put some things into perspective. Dr. Kesel Atoforsen was Deputy Finance Minister. He issued letters of credit.
Which is not payment.
Which is not money.
No, it's not money.
Good. But letters of credit will then be redeemed subsequently, and that will become money. So he issued the letters of credit on behalf of his boss, Seth Tekpe. Right? But the contention of the state was that there was no evidence of authorization from his boss, Seth Tekpe. And the justices, the two of them, are saying that the only way to establish whether there was an authorization or not was to hear from the one who had the authorization.
Who is alive?
Who is alive?
Seth Tekpe. Yeah.
The state didn't call Seth Tekpe.
No, they didn't call him to.
The state didn't call Seth Tekpe to come and find out.
To come and testify.
Whether you authorize your subordinate.
That was what the case.
And that was the basis on that leg for the two justices of the Court of Appeal to say that, no, you had every opportunity to go beyond the conjecture.
Yeah, and go to Seth Tekpe.
He did it on his own accord without authorization.
And ask the man who was his boss whether he did it.
You didn't.
Yeah.
That's one. Two, the LCs were issued on behalf of a ministry. The ministry, after the LCs were issued, went through processes, including the BOG seeking for consent from the Ministry of Health before the LCs were turned into money. Those authorizations were not sought from the Deputy Minister of Finance. So, if there are questions to be answered, and of course, the justices believe that there are questions to be answered, but only that the questions should not be answered by Atoforsen. So, yes, indeed, people should be put on trial. But those people are not those people we are putting on trial. In fact, some of the monies were paid in 2017. In 2017, the NDC administration was not in power.
For these ambulances.
Exactly. So, I think that it's our decision as a state to pick and choose who is put on trial. That has landed us where we are. Let me read briefly. I'm sure.
No, but there are even certain aspects, because when you look at the Attorney General's statement, right, and he talks about the ambulances not being fit for purpose, but the ambulances are imported into the country.
Yeah.
And when ambulances are imported into the country, the ambulances are not imported already fitted.
Exactly.
They are imported, and then the parts that are supposed to be used to make the ambulance an ambulance, the equipment and all of those things, are then fitted into the ambulance, right? And this is one of the arguments that the accused persons have been making in court as the case was going on in the High Court. That, yes, of course, when the vans come, they are not ambulances. They are they are not fit for purpose as ambulances. But when the equipment which is supposed to make the ambulances an ambulance are fitted, then we can call it an ambulance. And we're also told that the parts which were supposed to be fitted in have already been imported into the country and were supposed to be fixed in. But because of all of these legal issues, that has not been done. And these are some of the arguments. Correct me if I'm wrong, because Mutala Inusa has also joined us in the studio. He's a man in court. He's the one who broke the news to us yesterday, right after he left here, after telling us that we're expecting that case to be called in the Court of Appeal. A lot of people were expecting that the Court of Appeal will say, yes, the High Court's decision to allow Jakpa and Dr. Kessler to force him to open their defense is upheld. But everybody was surprised. So correct me if I'm wrong. These are some of the issues that have been coming up in court, right?
Absolutely,
with
yes. Yesterday,
and the equipment that have been imported
exactly.
and all of that.
So we heard so many times, and across examination, Mr. Jakpa was explaining countless times that you can even use a container, a boboya, and convert it into ambulance. You can use containers, convert them into ambulance. You don't go to the market saying that you are buying ambulances. You buy vehicles and you convert them into ambulances. So they, first of all, the reason they bought that particular specification was that they were going to be used in areas where the roads are that bad. And for that matter, you need vehicles that are stronger. You need vehicles that can survive those unmotorable roads. So that is how come they choose specific vehicles to be converted into ambulances.
Yeah.
So first of all, they brought in vehicles. They are not ambulances. But of course, there were certain things that you need to add to make it ambulance. And that is where the controversy lied and all that. So
where were those things?
Those things, he said that they were brought. The container for which those things were brought came to Ghana, were offloaded, and it's gone back to China empty. So where are the things?
Yeah, so where are the equipment?
Where are the equipment?
Yeah, but I mean, the Attorney General is also saying something else. And of course, you have been reporting on this matter in court, so you can help us understand. He says that the vehicles were defective. When the vehicles arrived, they were not the kind specified in the contract. Further, apart from the absence of basic parts and equipment, which we've just talked about, required for an ambulance, the National Ambulance Service and the Ministry of Health noted serious defects with every material part of the vehicles. So the vehicles, the empty vans themselves were defective. This is what the Attorney General is saying. And that it was so fundamental that Alex Segbefia, I believe Alex Segbefia came to court to testify.
No, he was supposed to come as part of those who were subpoenaed by Mr. Jakpa.
So he had not come to court to testify yet. So they said Dr. Alex Segbefia said described the vehicles as ordinary vans not fit for purpose. In point to the fact that a report on the vehicles by an authorized dealer or authorized dealers in Mercedes-Benz commissioned by the Ministry of Health to assess the vehicles stated that the vehicles could never be converted into ambulances. But I've spoken to Alex Segbefia on a number of occasions on GH1 TV, and he has indicated that when he said the vehicles were not fit for purpose, he meant that as the vehicles have come in as they are not fit for purpose as ambulances until they are fitted with whatever equipment they need to be fitted with. That's what Alex Segbefia has told me personally on the record.
What the supplier indicated was that when these equipment comes, they have to come, inspect, install it, train personnel before they hand it over to government.
Right.
The argument has always been about who inspected this whole equipment and ambulances, and at what criteria was it used to say that they were defective. At the first place, Big C was not even allowed to come and carry out what was contained in the contract to say that when all those things were imported, the ambulance, the vehicle, the parts were imported, they will come, inspect, install, and hand it over to government. As we speak, it has not been done. So where did government even conduct this?
Well, Attorney General says the Ministry of Health, commissioned.
So it's one of the things that Mr. Jakpa was questioning
to do all this.
So who even handed over to you? Who was there when this inspection was? So that is why he said this whole thing was politically motivated and it was mischief. Because for him, what was supposed to have been done had not been done. And then you jump to say that the vehicles that were brought to the market were not fit for purpose. And that's how come he's been so vocal, he's been so loud and saying that the Attorney General did not even understand what the contract is, and he didn't even understand the case that he took to court. So these are some of the arguments that Mr. Jakpa, who is in relation to that, have been saying in all of this.
Now, IB, you mentioned something earlier about some 2 million that we could have recovered, and it became, the subject of some sort of plea bargain. It was proposed, and the Attorney General refused. Murtala, on that particular score, what was all of that about, in court about some 2 million which was being offered? Because another argument that is being made is that, well, if there is no guilt anywhere and there's no financial loss to the state, why is there an offer of money to be paid back to the state?
And Murtala, before you come in, that offer was made by the supplier.
Big C. Yes.
And the explanation that accompanied that request was that there's so much noise surrounding these vehicles. We are offering you 2 million euros. We're taking back our vehicles. Everything.
Yeah.
We're taking them back.
We'll take our vehicles back. And we offer you 2 million.
And we offer you 2 million.
Yeah, euros.
And in return...
And the whole contract is 2.37
million.
2.37 million
the
euros.
contract sum is over 15 million euros.
Yes.
But the ambulance ought to come in batches.
Yeah.
Exactly.
So the batch that had come was worth 2.37 million euros. And they had offered, we'll take our ambulances.
Yes.
We'll take back our ambulances.
Yes.
Take your 2 million euros.
And AG's contention was Jakpa pleading guilty or admitting guilt, one.
Yeah, by Big C offering that.
Or if that is the case, is Jakpa the one going to pay the money directly or the supplier? Jakpa says no. I was the country rep for the supplier or agent for the supplier. Because of whatever is happening, the supplier then says, I will pay, then you just gain your freedom. Let's end this noise, I'll pay. The AG then says, if the supplier doesn't pay, because the supplier is not on trial, I cannot hold the supplier responsible. That was AG's argument.
Yeah.
In summary, that was AG's argument to say that I'm not taking the plea bargain or the offer to pay the 2 million euros. That was it. So, that's why I said that for now, if what the Court of Appeal has given us by way of judgment stands, then it means, give or take, the country has lost that money. Because if we had then said that, okay, you know what, Jakpa, this is the deal you are bringing through the supplier. The supplier is bringing through you. We accept. We are taking the money. We will have gained. Regardless of how you look at the argument.
But the thing is that the ambulances are there.
As we speak today.
Yeah,
but some of the gadgets are still
there.
Come again.
Some of the gadgets we are told are missing.
Yes, Jakpa said they were missing.
Yeah.
Because he said we were at the port and it's been stolen. That, in fact, that was where
the equipment which is supposed to make an ambulance.
Yes.
All the medical equipment that was supposed to be installed
arrived
at the port
for purpose.
And he had evidence to that effect that
So yesterday, when you listen to if you read the judgment of the Court of Appeal, it said that, look, those equipment that were brought, the Ministry of Health is aware of it. The Ministry of Health is supposed to go for those equipment and make sure that whatever they need to install to make it fit should have been done. But they because it was not them who look at or who initiated, it was not them who did with this whole ambulances, then let's leave it there for the person who initiated the action to come and face the consequences. That is how come the whole thing was left. Yeah. And the court is wondering, if there's anybody that caused financial loss to the state, then should be the Ministry of Health and the leadership of it. So that is one reason why somebody like Dr. Sylvester Nebana, name is always been mentioned, because the chief director.
Yeah, he was discharged,
absolutely.
Right?
Yeah, he was discharged purely because on health ground. I don't know that for a fact. And so you could see clearly that you cannot leave the principal people out there and then the people around it, you subject them to prosecution. That is mainly the argument. In fact,
that's the argument that the Court of Appeal is making.
If you listen to...
if you are there, if you are not there,
yes,
just to buttress the point, the Ministry of Health was to ensure that
pre-shipment inspection.
You are reading from the judgment.
Yes.
From the judgment.
Yes, the Ministry of Health was supposed to ensure that pre-shipment inspection had taken place and all the conditions of the LC were met before payment. Not doing so, to my mind, was an inexcusable and reckless, because it is the Ministry of Health which approved all the payments apart from those ordered by the court after A3, and A3 here is JAKPA. Mm-hmm. After A3 sealed Big C General Trading LLC. So JAKPA, as an agent, had taken a legal action against even the supplier, to ensure that some things were enforced.
So you remember that at a point in time, they were told that he received some about 700,000 Ghana cedi of a sort. And he said that, yes, those were legitimate monies, goes into transactions, remunerations, and other stuff. Yeah. And I went to court, and the court gave him that money.
Yes. And finally, it says, in my view, therefore, if anyone was culpable, it ought to be those in charge of the Ministry of Health and not the Deputy Minister for Finance, who from the evidence officially performed his duty. Mm-hmm. And if you go into detail, you are told that it's assumed per our laws that any public official who is performing his official duty is doing so without malice until otherwise determined.
Yeah.
So issuing the LC from the beginning is not, in the opinion of our laws, that Atuforsen was doing so with the intention of causing financial loss
to the state,
unless otherwise established. And that's what the court was seeking to establish. But per the evidence, and now I think Mutala can read the rest.
So let me just take you to
this is
the analysis of
the two judges, right?
The
two judges who said there is no case. Exactly. But then the presiding judge dissented.
Oh, yes.
And he also has his reasons.
Yes,
so we need to get into that as well.
Let me just go to Justice Alex Poku Echampon's reasoning. In fact, the last one that he had to, let me just go to where he was making the point by Mr. JAKPA. And it's all, I do not, and I'm quoting from one of the his opinions.
In the judgment.
Yes. He said, look, I am of the opinion that, so he was making reference to one of the decided cases, for which reason he thinks that the action of the accused person should be held. I said, having concluded the third accused person can be held personally liable for his action and omission, we will now consider whether these acts. So he went ahead, and in conclusion, this was said, I conclude therefore that the trial judge did not err in ruling that third accused person, Mr. Richard JAKPA, has a case to answer. Okay. He went on to say that, in my opinion, the submission of no case in respect of third accused was rightly rejected by Justice Ifiasewa Saribotwe, and the third accused has a case to answer together with the first accused person, Dr. Kaisel Atuforsen. I have, in arriving at this decision, discussed all 5 grounds of appeal of the third appellant, and I conclude that they are not meritorious. So this is the view of Justice Alex Opoku.
He was a presiding judge, right? And he's the only judge who dissented.
Yes.
Yeah, but the
so
two
that
other
was
judges.
How come it was today. And in conclusion, he said, in conclusion, the learned trial judge did not err in her ruling that first applicant, that is Atuforsen, and third applicant, and I conclude that they should be made to answer the questions.
Yes. So that doesn't even prove their guilt, right? That just says that, okay, there are certain things that are, a bit fishy, and so open your defense.
Yes.
Right?
So
and defend yourself.
For those who want to understand what this submission of no case is all about, it's not about when the prosecution is done with this case, it's not about the court examining the entirety of what the witnesses have come to court to say, because at that particular point in time, it is one-sided. You don't have anything to compare with. All those witnesses who have come are for one person. So what about the other persons? But the court ought to look at it on the surface of it and ask whether there are certain things that is lingering in the minds of the court that the court will want explanation, and that has to be sufficient enough. If you just scratch the surface, it cannot be sufficient enough. So yesterday, when you read the decision of the court, and let me point out to you one of the things that Justice Kweku Tewia Aka-Boafo said. Let me take you to paragraph 72 of his opinion. And then he made a very interesting analysis when Kweku Agyeman Menu came to the court and the kind of things that he came to say, especially at one point in time when he was saying certain things, and another point in time he was trying to get away with it. So this is what Justice Kweku Tewia Aka-Boafo is trying to say in relation to the views of I'm trying to get that one in a bit.
Yes.
So I've just found that particular paragraph. So paragraph 69. He said, "My lords, Mr. Kweku Agyeman Menu also testified for the prosecution. At the time of the testimony, he was the Minister of Health. In his evidence, he told the court what happened during the transition period and what he did as the appointed person in charge of health, and also what he did after he was nominated by the president as the Minister for Health. Mr. Agyeman Menu testified about the letter from the AG advising the Ministry of Health about BC's intention to sue the ministry and the ministry's response. He also testified about the post-delivery inspection of the ambulances and the report written, which indicated that medical equipment which ought to have been in ambulances were not in them. He also considered that the equipment later were shipped to Ghana and at Tema Port, but said they were not cleared because, according to him, the ministry did not have all the funds to do so. And many documents were tendered in that, and the court went ahead to point out what transpired and across examination. Let me give you the excess of this. What happened between Kweku Agyeman Menu and lawyer for Dr. Kasiel Atufose, Dr. Abdul Basit Bamba. Have you said the question that word? And you have also served as the chairman of the Public Accounts Committee in Parliament. Is that correct?
That's a question from Kasiel Atufose's lawyer to former health minister.
And he said that's correct. So you have quite a working understanding of how LCs operate, and that's the letter of credit. Operates. Is that not correct? He said, yes, I do. Are you aware, are you not, that the LCs are not payments in themselves, but a guarantee of promises of payment subject to certain conditions being met? Is that not so? He said, that is so. Then he went on to say, so if the Ministry of Finance requires the BOG to establish an LC, that does not mean that the BOG should make payments under the LC. And it is what Kweku Agyeman Menu says. It means the finance is authorizing BOG to make payments on certain conditions. And of course, if those
the key word here is on certain conditions.
On certain conditions.
Yeah.
Then the question again is, and of course, if those conditions are not met, then payment should not be made under the LC. Is that not the case? Then Kweku Agyeman Menu say, yeah, that is the case. Kweku Agyeman Menu said that is the case. And in analyzing that, this is what Justice Aka-Boafo said. He said, Kweku Agyeman Menu also told the court that if LCs has not been established, payment cannot be authorized. He also said that even though the letter requesting for the LCs is the primary document, the Bank of Ghana will not be able to establish an LC with the letter only. Those are the things that said. Then he went, interestingly, that's one of a contrasting opinion. Interestingly, despite the very clear and unequivocal answers above about the LC was not a payment but a guarantee, Mr. Agyeman Menu later gave a different answer on August 30, 2022, when he said that per the terms of the contract, payment should be done by LC. Therefore, a request by LC to be established meant requesting for payment to be made. My lords, due to these inconsistencies in the record of the evidence of Mr. Kweku Agyeman Mensah, I consider... I don't know why I give it to Kweku Agyeman Mensah. Kweku Agyeman Mensah is one of the ministers of water resources.
Yeah.
That's how That's Kweku Agyeman Mensah, former minister for it. I consider his later evidence as unreliable and place no weight.
So essentially, when Kweku Agyeman was giving evidence, there were inconsistencies in his testimony.
So at one point in time, you are saying that the LC clearly stated that offer. Just go ahead and do payment. And I want to say that you satisfy certain conditions. So what exactly is the LC supposed to do?
But essentially, LC is not payments.
It's not payment.
LC is saying we will pay you when we see there's a guarantee that we will pay you, but we will pay you when we see A, B, C, D. Then we release. But if we see A, B, and we don't see C and D, even though there is an LC, we are not obliged to pay you.
So
that's what LC really is.
One of the prosecution witnesses who came to court was trying to put spin on it. If you look at the letter of LC that was written to the BOG, it says that it was a request. But if you look at the testimony of the witness in court, said that the first accused person instructed, when indeed in the letter he said that the request, you're making the request, and the request means optional. You look at it.
You can grant.
Yes.
You can grant the
request. There are so many times that I go to court and I put a request to the registrar. I say, I want a document of AB. The registrar can reject it.
Yeah, because it's a request.
It's a request.
An instruction is different.
Yes, an instruction is probably me having a letter. The CG has given accreditation. Said, go and serve me. And when I bring you the letter and say that I've been instructed to come to you. So there are two different dynamics. And those were the things that the justices, particularly Justice Kweku Akabuafo, made in his analysis. In fact, he wrote the lead judgment, and he made clear in the analysis that these are some of the things that they think that the evidence at the High Court are not reliable enough for the accused persons to be called upon.
Let me give you 79.79. So it is tried. And in this case, Mr. Eduma Mensa, who is Eduma Mensa, in his testimony, affirmed that in all situations, the Ministry of Finance authorizes and approves public financing of ministries and in effect, government departments. To that extent, it is my view that requesting the issuance of an LC on behalf of the Ministry of Health was not out of place by the first appellant as a Deputy Finance Minister. This was done after the AG had received notice of intention to sue for breach of contract by Big C and advised the Ministry of Health of the consequences of non-compliance. Again, it is tried that in the context of performing official public act, there is a presumption of regularity until contrary proof. And that was what I was relating to. Now it goes further to say that this on account of section 37(1) of the Evidence Act 1975, specifically NRCD 323, which provides that, quote, it is presumed that official duty has been regularly performed. My lord, this is rendered with some classical flourish of Latinism, of course, and then gives you the Latin rendition of all this. And the meaning is that all things are presumed to be done in the proper and regular form. In my view, the principle applies to the performance of public functions by no less a person than a Deputy Minister for Finance. He occupied a public position and performed public functions, which are presumed to be correct. It is noted that Ghanaian law stipulates that such presumptions are rebuttable. This leads me to the next leg of the analysis, which is whether the first appellant had authorization for the letters he wrote. If he had no authorization, then the presumption will be deemed. And so, so if you are not authorized, the presumption will be deemed. Okay, so it continues. That will be yes. Your presumption will be deemed as ineffective in that end. And the only way, and I'm just summarizing, the only way that presumption could be deemed to be accurate or inaccurate will be finding out
from the substantive minister
whether he
of
gave
finance,
Seth Terkper. So the judgment goes further to say that the state failed to do that. To ask him that direct question, did you authorize your deputy or not? But the state proceeded on a conjecture, and I'm quoting the judgment, conjecture and presumption. And here says that Atuforsen did this on his own accord.
And in all of this, Seth Terkper has been there.
Yeah, so subsequently he came
he was in court to testify for Dr. Akisel Atuforsen, and he said that yes, he gave authorization for the deputy finance minister to go ahead and establish
because September has been there and it came to light.
Attorney General contends that he didn't come with any documentation to prove that yes, this is what you said. And
no, but I'm giving testimony. I am the minister.
So
I am the minister responsible for the sector.
For general law,
and if I
want to prove
exactly
you that you are accusing,
you should prove
it in the judgment. Like, you need to prove that.
As an accused person,
he's not the one coming to prove your case.
You need to prove. I don't need to prove my innocence.
Yes,
I am the minister in charge of the sector, and I'm telling you that I told my deputy to do it.
Exactly.
So, like, prove that I didn't.
It begs the question: how many times have we not seen statements from the ministry, the institutions saying that I am in charge of corporate affairs, signed on behalf of the minister, of the CEO or whatever is in charge? We've seen that countless times and all that. So it was a very issue. So it was one of the reasons that the minority, particularly the NDC, is saying that look, Kweku Agyeman Menu should stand firm because this is big issue and all that. When we come, we'll revise that because now you are veering into an arena that is so slippery. You are coming to court to testify in relation to the matter that you yourself have been doing that virtually much more every day. But you see something wrong with your predecessors' team and all that. So it was very a tricky issue. And you could see clearly from the decision of the panel that, yes, they think that whatever was happening, the evidence that were adduced were not sufficient enough for the accused persons to respond to.
I mean, so essentially to help people understand what is happening here, the High Court case where Jakpa was still giving his
calling
defense
witnesses,
and calling witnesses. He had already subpoenaed witnesses. The Chief of Defense Staff had come in to come and testify with regard to his character during his days in the military, whether or not he was discharged from the military based on misconduct and all of that. So the trial was going on.
Yes.
Essentially, all of that has ended.
Yes. So for those who remember, in fact, few days to Christmas, 2021, that was when prosecution filed this case against Dr. Kizela Atuforsin, Dr. Sylvester Ademana, and then Mr. Richard Jakpa. And Dr. Atuforsin, because he was the deputy finance minister at the time, Dr. Sylvester Ademana, because he was the chief director of the Ministry of Health at the time, then businessman Richard Jakpa, the agent of BC. And the charges, in fact, the counts were 5. Dr. Forsen was facing 2 of them, willfully causing financial loss to the Republic, and 2, intentionally misapplying public funds. And then 2 of them were also being faced by Dr. Sylvester Ademana. The Mr. Richard Jakpa was facing a count of willfully causing financial loss to the Republic.
So his was just one count of
Absolutely.
willfully causing financial
so
loss.
Prosecution, the Attorney General called 4 witnesses, including Kweku Agyeman Menu, the Minister of Health at the time, to come and testify. So it was at the conclusion of prosecution's case, when situations happen like that, sometimes it is even a mandatory on the court to find whether there's a prima facie, there's a case for, even if the accused person did not file. But of course, the accused person will have to make that request because they will need to file submissions to justify, to be able to pinpoint some of the consistency and inconsistency for the court to take note if some of them probably might have been an oversight. And so they filed, all the parties filed their written submission of no case. Attorney General responded. Then on the 30th of March 2023, Justice Effiasewa Asare-Botwe made a ruling on the submission of no case and held that there's a case for Dr. Kizela Atuforsin, Dr. Sylvester Ademana, and Richard Jakpa to answer.
So they should open their
defense.
defense.
So they should open their defense, which the court gave them time to come and do so. The lawyers were not satisfied with that, so they appealed. This appeal that we are talking about, that the Court of Appeal has given decision.
So this was done last year?
It was done as far as last year, not this year.
Justice Effiasewa Asare-Botwe had given her ruling that they should open their defense.
Before even the accused person
were not satisfied.
Absolutely. Even before the accused person will even open their defense. They have filed their appeal.
So they decided to go to the Supreme Court, saying that there is still an issue of no case. They believe strongly, and so the Court of Appeal should deal with that.
Absolutely.
Right?
So the Court of Appeal should quash it. Effectively, what they are asking the Court of Appeal, let us go, because the Court of Appeal, the High Court is saying that we should open, and we think that there's no case for us, so intervene. But that case has been pending. So once the Court of Appeal has not said anything yet, that means that they have
High
to
Court case,
be
there's the green light for it to go on.
So subject yourself to the law, and that's how come Dr. Kizela Atuforsin was in court, a court witness. In fact, he personally did not testify because he was of the view that Those who came to court to testify for him, including his boss, his former boss, Mr. Setekpe, were able to prove his case to the extent that he didn't know to come, and the law allows that. Step in the witness box and open it, and he closed his case. Then Sylvester Anemana also stepped in the witness box. He testified by way of giving his evidence in chief, and he was subjected to cross-examination by lawyers of Dr. Kessie Latour-Forson. And when he was in the box facing cross-examination from lawyers of Richard Jakpa, after which the AG would take over, the issue of his health came to the fore. And so at one sitting, I remember that the question was posed to him for about 10 minutes. He could not even open his mouth. That's where the court held that no, where it has gotten to, the man ought to be granted the opportunity to seek further medical evaluation. So he was taken out of the country. The court wrote to the Chief Justice for a warrant where he will be made to join via video link wherever he is, as long as he is fit. So once he's able to join and he's active, the trial will proceed. One time, the warrant was granted, a video link was established far away from China. He joined, and it was the wife who was with him and said, the man has been on theater, he cannot even speak. It was then that the Attorney General made his mind that, yes, my lord, we don't mind, we want to dispense with the services.
So want to discharge him.
Absolutely,
So
we want
no
to file a nolle prosequi. So days later, it was on the 8th, I remember, 8th, the day was on the 8th, and on the 11th, the court AG filed a nolle prosequi. He didn't have to even attach any reasons to it. We want to discharge the second accused person. So that's how come Mr. Richard Jakpa was dealt with. And then once he was in the box,
Anemana.
Yes. Okay.
Sylvester Anemana.
Dr. Sylvester Anemana, yes, the former chief director of the Ministry of Health, was discharged. So once he was discharged, the next person is Mr. Jakpa. And then Mr. Jakpa was invited to come and testify. Notice at the point in time, he had an issue with the lawyer to the extent that he asked the lawyer to. And in fact, yesterday, I've been speaking to that lawyer. He filed the submission of no case on behalf of Mr. Jakpa. Before he was, Jakpa dispensed with him and brought in Thaddeus Sorry. And also yesterday, he was in court and was so happy. He had some interviews that we'll play later on. He was so happy. So it was when Mr. Jakpa was testifying. Now, the appeal processes were also happening. It was happening at one of the, sometime last month, the court gave timelines for the parties to file their respective submissions, which they did. And yesterday was the day that the court, and the same yesterday, they were able to appear at the High Court for Mr. Jakpa to call the third and fourth witness to testify. And remember that some of his witnesses were also pinned, because initially they are not willing to come to court to come and testify. The court is inviting them to come and testify and all that. And they came. And for them, the Court of Appeal heard them and aware of the view that evidence that were led at the trial court, the High Court, before Justice Efia-Sewa Sariboche, not reliable enough. There were so much inconsistencies, the witnesses who came, and the manner in which the contract issues happened. You cannot blame Dr. Kessie Latour-Forson and Mr. Richard Jakpa. Those who are supposed to be blamed, the officials of the Ministry of Health, who watch on concern for these things to happen. Absolutely to happen. So you cannot hold these two people accountable, which led to they being acquitted and discharged. So in a split decision 2-1, the Court of Appeal is saying that no,
these people are free.
Yeah,
an acquittal and discharge means that, I mean, once you've been acquitted and discharged, they can't even try you on that case again.
Absolutely not.
Otherwise, that is what they will call double jeopardy.
Absolutely.
So they can't even try you on that
again.
In
respect of this case, as far as the Court of Appeal is concerned, Dr. Kessie Latour-Forson and Richard Jakpa are free on those counts. They can never be charged until such time that the Attorney General is saying that I want to appeal, which he has given the indication that he wants to go to the Supreme Court. So we'll see what will happen from there.
So there have been some reactions, right? You've been speaking to some people. I think there have been some reactions from Richard Jakpa. Yesterday, for example, when I spoke to you on Newsroom on GH1 TV,
yes. So yesterday,
you had earlier met Richard Jakpa at the Court of Appeal, and then you met him again.
Yes,
at the High Court, and he said he was coming for his passport, right?
So I asked him a simple question. So now the Court of Appeal says that you are free. You are supposed to appear before the High Court. When you go to the High Court, how are you going to the High Court? He said, yes, I am going to the High Court to show myself to Justice Efia-Sewa Sariboche to let her know that I'm no longer under her control, and to ask him to give me my passport. And the reason he is saying that is that as part of his bail conditions, he's asked to deposit his passport at the registry of the court. at the registry at the court. And so now that the court has freed him, he has to go and his passport will be released to him so he can travel anytime, any day that he wishes to. Until such time that the Attorney General takes steps to file an appeal at the Supreme Court, Dr. Cassiel Ato-Forson and Richard Jakpa are free forever. The Court of Appeal has today, in a split decision, 2-1 of course, ruled that the order by Justice Efia Sewa Saribotwe on March 30, 2023 for the accused persons to open their defense because a prima facie evidence has been established against them is in error. The panel, the two of them, were of the view that it was anybody to blame in relation to this whole ambulance cases. It is not Dr. Cassiel Ato-Forson nor Richard Jakpa. It is rather the Ministry of Health. What the court said was that the evidence that was put before the High Court was not reliable, for which reasons Dr. Cassiel Ato-Forson and Mr. Richard Jakpa are to be called upon to open their defense as per the order of Justice Efia Sewa Saribotwe. Consequently, Mr. Richard Jakpa and Dr. Cassiel Ato-Forson have been acquitted and discharged. What this means is that they will no longer appear at the High Court to stand trial. They will no longer be here to respond to charges. Mr. Richard Jakpa, who is calling witnesses at this particular point in time, will have no business bringing his witnesses to court again before Justice Efia Sewa Saribotwe. In effect, the trial has come to an end until such time that the AG decide to appeal. Richard Jakpa has this to say immediately after the Court of Appeal's decision.
I've been vindicated by the ruling of the appeal court. I've always said that I'm an innocent man and I'm being persecuted for political reasons. And the Court of Appeal has vindicated me on that stand that I've always been saying.
But of course, he's also been talking about the window of opportunity that is available to the Attorney General if he so decide to appeal. If you look at what is happening now, the Court of Appeal is saying that you've been acquitted and discharged. But the Attorney General has another option to go to the Supreme Court. Would you be surprised if they activate that?
Oh, that is his prerogative. He's Attorney General. He can go to the Supreme Court, and even after the Supreme Court ruling, he can still go for review if he so pleases. It's a legal process. And I'm a combatant. I'm a warrior. I'm ready for every battle. So if you want to go to the Supreme Court, I'll meet him there.
There's one thing about Mr. Jakpa that many do not know. He's always in court with that handbag. What exactly is in that handbag?
Handbag is relaxing.
It's relaxing. Why?
Because the handbag was for a particular purpose. It was carrying evidence.
What was in the handbag?
Evidence.
Evidence in relation to?
For my liberty.
The case that you were fighting?
Yes.
I thought that your lawyers had those documents.
They have. I also have mine. I always have a backup.
Oh, okay, so you had backup.
You never know what can happen.
Those were in there.
They can burn your lawyer's office. They can burn all the documents. These people are capable of anything.
So why did you not?
Akufo-Addo was a minister of foreign affairs. Didn't they burn the foreign affairs? Didn't they burn all the documents there?
That's why.
GRA office at going to circle. Didn't they burn that place and all the documents got missing? And you can't even find how to get people who. So they are good in burning offices and their documents.
Which people?
This government, MPP government, they are good in those kind of asking. They are very good in it. So I need to have backup for my lawyer.
But of course, the otherwise decided, Dr. Cassiel Ato-Forson and Richard Jakpa will no longer be here at the Court of Appeal. In fact, today being one of the days that Justice Efia Sewa Saribotwe fixed to hear the trial, to hear witnesses of Richard Jakpa, the trial did not come on, all because of the decision of the Court of Appeal. From the Law Court Complex here in Accra, Murtala Inusa, GH1.
So that's your report, the report that you filed.
The report that I filed yesterday.
So we had Richard Jakpa
today that you hear.
there.
Yes, Mr. Jakpa. You notice that he always comes to court with that
his briefcase.
That briefcase. So yesterday I wanted to find out
evidence.
what has been in the briefcase, and he said that is
Richard Jakpa
evidence.
is an interesting
Yesterday
character.
he didn't carry that with him. Yeah, so he was
Because
like,
he's a free man.
I said, look, I am a free man. He said the bag is resting now because now there's no need to carry the bag to court again and all that. So yesterday he's been very happy and all that. But let's also listen to another side of the interview that we had with him, Mr. Jakpa, yesterday after the decision of the Court of Appeal.
Well, I'm not surprised because I knew all along I'm innocent. I've done nothing wrong. You cannot leave a principal and come and charge his agent and say the agent should answer for any deeds that you claim might have been committed by the principal. I find it very difficult to understand. So I knew very well that I was going to be acquitted and discharged. I knew because I know that a Court of Appeal will have men of integrity there. So I'm just going there for justice. If yes, they want to see my face and let her know that I have no issue with her. I'm no longer under her jurisdiction. I'm no longer in her court. For her to be abusing me and intimidating me and threatening me with contempt and abusing my human rights and all the open biasness that she's doing against me, she'll no longer have it again. It has been taken off her hand. So I'm going there to collect my passport. I'm going to collect your passport. Your passport is with the court. It's with the court. So I'm just going there to see her and get my passport from her. Okay.
So that's the Richard Jakpa once more.
Yes, yesterday, immediately after the Court of Appeal acquitted and discharged him. So I was asking him what he was going to the High Court to do, because the court had then fixed 12 o'clock to sit. And I said, no, now I am going to show myself to Justice Efiasewa Saribochi to let her know that I'm no longer under her control and for her to release his passport to him. So those are some of the reactions from Mr. Richard Jakpa. And Lantam, it was an interesting. Dr. Kazil Atufosin wasn't at the High Court, because immediately the Court of Appeal spoke.
He at the Court of Appeal? He was at the Court of Appeal right?
Yesterday. Yes, he was present together with the lawyers. Dr. Abdul Basit Bamba, Eduji Tamaklo, then Bafo Jeubo Zishia for representing title. Sorry for Mr. Jakpa. All of them were at the Court of Appeal when the panel took the decision. And straight from there, they went to Parliament, and you heard that Parliament were celebrating. In fact, the minority were celebrating that. And in fact, they sent a word of caution to the Attorney General, saying that if he decides to appeal, he will disgrace them more. And these were all some of the things that took place in relation to this very matter and all that. But what is clear is that the Tuesday and Wednesday sittings, the Monday, Tuesday, Wednesday, all of them have come to
all of that has come to
in relation to what the decision of the Court of, and that is how the law works. Once a decision is taken, but some people will be hoping for a different outcome, a different way for this whole matter to end. But it's just one moment, and the whole thing is off, and that is the kind of law that we practice here. So, as the AG said he's appealing, yes, there's that window of opportunity for the Attorney General to appeal. They go to the Supreme Court. Even if they are not happy about the initial Supreme Court decision, they can also go on a review, whichever decide to do. But for now, what is clear is that we will not come here and discussing the issue of ambulance as far as this particular issue is concerned. Yes.
Unless we see the application that is done at the Supreme Court by the Attorney General.
Absolutely. That is the
then
only
we
way
can talk about
we'll
it.
Come
we've
back
not
and
seen
then
it yet.
Revise or review the issue of the ambulance.
So, I mean, that was the biggest case from the courts yesterday. We've extensively and in a detailed manner dealt with it. But there are other cases in courts, right?
Yes.
The Gen Z demonstration. You told us yesterday that the court was going to hear their injunction application by the police.
Yes.
With regard to that demonstration. Yes. What's happened
in that
regard?
Justice Mary Mami Ekwe yesterday. Justice Mary Mami Ekwe yesterday heard that particular request, and in fact straight away granted upon hearing submission from the party. So that particular demonstration, the Gen Z demonstration that was supposed to start today. It was supposed to start today up to until August 6th. Because it's a 7-day
demonstration.
Yeah, absolutely. That did not happen. So yesterday the Court of Appeal, the High Court in fact did not allow that. But we can go and see what hear from Mensa Thompson, one of the organizers, what he has to say about this whole decision of the court not to allow their process.
Nowhere in the Public Order Act does the law prevent the holding of special events during election years. And so we are indeed at a loss on what point of law, on what basis the court has granted this application. But we want to entreat our supporters to remain calm, all the young people of this country to remain calm, to not lose hope. We are poised in our efforts to ensure that their rights, their democratic right to demonstrate, will be respected by the state. And so today, right from here, we are submitting another notice to the police again, giving them conditions in accordance with the Public Order Act for the holding of the Gen Z demonstration, because that demonstration will come on at all costs. Whether today or tomorrow, the police might have won at the courts today, but the battle still remains forward. We are willing and poised.
So that's Mensah Thompson there speaking to you with regard to the decision that has been taken by the court to uphold the injunction application of the Ghana Police Service.
Yes, so yesterday the High Court dismissed that. And so that demonstration will not come on. It will not come
The 7-day demonstration will not come on.
Certainly will not come on. They have to go to the police with another request for that to happen.
Okay.
So what is clear now is that today's demonstration, they are saying that they want to put over 2 million youth on the street. That's how come they call it Gen Z.
The Gen Z demonstration.
The Gen Z, the generation Gen Z on the street. But they say that they'll go back with another request. You know, if you want to organize a protest, you need to go to the police, seek for protection, and notify them that you want to hold a special event. And the police made the case that we are approaching elections, and so the police would need a lot of personnel to be able to do all their. So that particular demonstration, 7 days, if they can even reduce the days, the police will be in a position to give them protection. The court found wisdom in that and said that the request from the police. So now they cannot. They have been injuncted. Yes.
Is it perpetual injunction?
This one is not. It's not perpetual injunction.
Interlocutory injunction.
This one is an interlocutory.
Okay.
Injunction.
Interlocutory injunction.
As far as this very case is concerned, they are not done. So they have to just go back.
Go back and then
Yes.
All right. So what about the issue of the reappointment of the
vice chancellor of
the KNUST?
Yes.
So what's happening there?
Some people are not happy with the reappointment of the VC of the KNUST. So they filed an injunction in court. The reappointment is supposed to take effect from tomorrow, 1st of August, and they want that stopped. So they went to the High Court in Kumasi for an injunction. Of course, unfortunately, the applicant did not succeed. The Court of Appeal dismissed that, awarded a court of 9,000 against them and all that. Let's go to Kumasi, where Isaac Justice Bediakon was in court, and he came through with this report.
During proceedings at the Kumasi High Court, the counsel for the plaintiff argued that the reappointment of the Vice-Chancellor was procedurally wrong, according to university statutes. They contended that the process, which involves constituting a 7-member search committee to propose an ideal candidate and advertising the Vice-Chancellor position for other viable candidates, was not duly followed. The counsel for the defendants, the university, and the Vice-Chancellor fiercely opposed this claim, insisting that they had complied with the reappointment statutes. Justice Frederick Tete, in his ruling, described the application as lacking merit and questioned the plaintiff's status as an alumnus of the university. The court awarded a cost of 9,000 Ghana cedis against the applicant, Clement Kofi Ohene Asari. Dissatisfied with the court ruling, Clement Kofi Ohene Asari told the media he would file a stay of execution.
I don't have to be a member of an association before I will gain status. So if a court is basing on my capacity as not a registered member of an alumni association, it goes to the extent that, or to undermine Chapter 5 provisions of the Constitution. Are you getting me? The case has just started. Today, we are filing a stay of execution just today. And I believe that we will have to wait till a better judgment or the law is looked at.
Shortly after the court dismissed the injunction application, the applicant did file a stay of execution and appeal against the defendants. However, a standoff erupted at the court premises as the bailiff attempted to serve the university lawyers, who argued that they needed to be served officially at the university, not the court premises. Speaking on behalf of KNUST University Relations Officer Dr. Norris Bequin, welcomed the court's decision and urged the aggrieved parties to resolve the issue amicably.
Today we are very excited about the outcome of what happened today in court. It gives us relief and the university can proceed peacefully. If anyone, as the judge has actually directed, that if anyone has any issue, we should be able to sit down and talk about it peacefully. This is not a matter that we should be bringing to the court to drag the name of the university in the mud.
Meanwhile, a staff member of the university has filed another suit on a similar account to injunct the reappointment of the Vice-Chancellor.
All right, so that's it for that particular case. And Murtala Inusa is still here in the studio with us, but let's switch our attention back to the issue of the Court of Appeals decision that Dr. Kessler Latto-Forson and Richard Jakpa are free men. What are the political connotations to all of this? We're being joined on the phone line by a political scientist, Dr. Richard Amoako-Ba. Dr. Ba, good morning. Welcome to the Morning Star.
Thank you.
And thank you very much for your time shared with us here on the show this morning. What is your immediate reaction to all of this that has been going on with regard to this case involving the purchase of ambulances? From the onset, those on the opposition side have said this is a very political case and a deliberate attempt to do political persecution. On the other side, the state, led by the Attorney General, believe that, well, if there's financial loss to the state, it has to go through the processes for the right thing to be done. You've been watching, monitoring all of this that has been going on, and what has been your thought process regarding all of this?
Oh, I stopped following it long ago. When the accusation was made that the Attorney General is trying to just, so to speak, get a majority leader. And we heard the tape where the President and his finance minister were talking about that would be the leverage for them to get the majority leader if the other party wins to do what they want. And that's when I stopped following it, because they all become corruption, really. And I don't think it's appropriate at all for the Attorney General to continue this case in terms of appealing or whatever, because the implications are there. People saw the shenanigans that's gone on, training, coaching witnesses and so forth, and witnesses not agreeing with him. That's not good. Attorney General is not there to just get people. You prosecute the right people. But it looks like this case has become too political. And then on top of that, when he finished, he made an interview in which pretty much denigrating the very court is going to appeal to. What are you going to do? This is not a good case at all. So our advice is just drop it.
I mean, if there is a firm belief held by the state, represented, of course, by the Attorney General, that, look, something untoward has happened, money has been lost, we need to recover the money, and the people who have misapplied that money need to pay. I mean, mind you, in the first instance, the High Court felt that there was a case to answer, and so the trial had already begun until the Court of Appeal came in with their decision. I mean, if the High Court and one judge saw that, okay, there is a case to answer, and even in the case of the Court of Appeal, there was one dissenting judge who also felt like the trial should go on and there's a case to answer. I mean, shouldn't the Attorney General want to explore the options available to him to really pursue this case to its logical conclusion?
Well, he has the right to explore any way he wants to. But what has happened ahead makes it very difficult to go forward, and it makes it suspicious, because we have conspiracy here and there, and it is true that they were trying to use this as a leverage. Why do you wait all this time to try this case? Why? It happened more than 8 years ago. Why the very last minute about to leave office are you bringing this up? You didn't know it? That is the problem. There's no credibility in it. The Attorney General is not credible. witnesses have argued with him to the contrary, that he's trying to coach them to say what he wants. All of that does not cast a good shadow on him at all. And so if you want to go forward and appeal, it is right. But I can tell you, if the MPP doesn't come back to the office, the case is dead. It becomes too political.
Do you see this attempt by the Attorney General to pursue the case at the Supreme Court as an ego fight or a fight to sort of boost his reputation? How do you see it?
In many ways, that's how I see it. Because he's supposed to be a free agent, non-biased, yet he's done all of that. He's biased, he's not a free agent, he has a stake in it, whatever it is. And that destroyed the reputation of a referee. That's what I see. And he's done all of that. And not only that, sometimes it comes down to incompetence. As I said, a case happened more than 8 years ago. What did you sit down all this time until the last minute when you are leaving office, most likely, is when you are going to try the case. And then we heard the president and the finance minister talking about this very case in the form of a conspiracy that is the leverage they will use to get the majority leader to do what they want. What else do you want to hear before you know this is too political? It is. The cat is out of the bag. The wind is out. There's no credibility in it. It means, most likely, what they were talking about is what you are trying to do for them. Which means, if you vote for Bawumia, then if you vote for the NDC, then they will come back and have leverage to use the majority leader to do their bidding. It comes to the same thing as voting for MPP again. So there's no credibility in it for me. That's how I see it.
Now, there have been calls by certain lawyers and other people who are in the legal profession for the Attorney General to be looked into as regards misconduct because of some of the audio tapes that came to light. It was leaked by one of the accused persons. It came to light where he was heard in conversation with the Attorney General about the case and certain issues. And so people feel that there is some misconduct in there and the Attorney General must be looked at in that regard. Where do you stand on that score?
That's how it should be, because if the attorney, this case, I can't say that the Attorney General would have won. But since he's lost so far, he brought about the losing of this case by his conduct, and he must be looked at. The Attorney General is not supposed to be a crook or a corrupt person who takes cases based on what he wants or somebody else wants. And the decision arrived at should be that the other people want. No. You try the case fairly. Sometimes you can even defend the person, accused person, as you go along. You find evidence that, no, this is not the case. But can this person do that? No. He himself wants to get him. And so he should be looked at. The Attorney General cannot act this way. It's misconduct, gross misconduct. So they should look at his dealings. Besides, his pronouncements are very, very, very unfortunate. Sometimes I would say it's incompetent. That's what it is. And so it should be looked at.
The president appointed him Minister for Justice and Attorney General. Any word to the president on this?
I don't think it will make any difference. If you have one corrupt person, it's not very different from two corrupt people. You understand? They may collaborate and be a bit careful before they come out. But all we need is a competent person, non-corrupted person to be Attorney General, and that's good enough. You see, in our situation, we don't have money. We have to cut down the numbers of government employees, and this is one of them. Why do you want to have Minister of Justice lawyer, Attorney General lawyer? Why? The Attorney General have so many people to advise him, you see. And so we don't need another layer before justice is done. I don't think so.
Now, in terms of generally our democracy, how do we situate lessons that can be learned, from this case moving forward there are some cases which are called political cases, among other things. And when these cases come up, you hear the side that it doesn't favor say, oh, this is politically motivated. And then the other side says, oh, I mean, there is a case to be answered. And so let the law take its course. And then it sort of brings some division, so to speak. So, I mean, politically speaking, when it comes to affecting our democracy, how do things like that, or how do we situate issues like this?
This is gradually eating at the base of our democracy. There's no trust in it because it's dishonest and shenanigans, plans. That is the problem. The Attorney General sometimes will be the one who acquits and accuses when he finds the evidence to the contrary. But this one, he's the one who wants to get people. He's doing the bidding of his master. It's not supposed to be like that. Attorney General should have no master. The master is justice. But this is what has been going on. It's so many things I can say that I don't want to because it will make the situation worse. If he wants to go ahead, he should go ahead. But if the court is going to hear the case again, it will not happen before the election. So the whole point is gone. That's the whole thing. We wanted to get him before the election is over. So if MPP loses, they use that as a leverage against the majority leader. That we heard them saying it. Now it's gone. That possibility is gone. So what do you do? And if you're going to go to court and appeal to the Supreme Court, why do you denigrate the very people you are going in front of to help you? The Attorney General and the court system, they are supposed to work together. Sometimes even the court can advise the Attorney General. You see, in the U.S., for example, when they get an arrest, a high-level arrest, they know the court they are going to, which judge they are going to give this case to, and which one, and so forth, because they are working together. They are working for the government. Here, we behave as if each one is on his own, because listen to what he's saying. He can't hold his mouth. What good is what you said against the court system and the judges? What good is that going to do? It means you are inexperienced. The short end of it is that he is very inexperienced. And so he should be looked into and put in his place so that the next one we get will not come and do the same thing. I'm sorry. They destroy the legal system.
Would you say, based on how the Attorney General describes the decision of the Court of Appeal in the statements that he released to the media, would you say the Court of Appeal perhaps should look at taking some action, because he says that the decision of the Court of Appeal is perverse in the quest for public accountability and the rule of law? And he further goes on to say that the decision of the Court of Appeal is grossly unfair to the nation and inimical to the fight against impunity and abuse in public office. First of all, is there really anything necessarily wrong with this? Because we are allowed to criticize decisions of the courts. This is a democracy, are we not?
The Attorney General himself, you are part of them, if he doesn't know that. And he has the audacity to say, look, the public prosecutor arrested someone for money laundering. What did the Attorney General say? He was fighting against the public prosecutor. Is that how it's supposed to work? They all work together. And yet, he took the time to make statements against the public prosecutor in the interest of the accused, without the trial going anywhere. This is suspicious. He's doing his master's bidding. That's all. Very simple. But it's not a good thing for any Attorney General to be talking about the court or the judges this way. You work together. You see, remember the public prosecutor went to court with Cecilia, that lady, I've forgotten her name. Cecilia Dapa.
Yes.
The judge could have advised the public prosecutor, hey, just remember, you don't have too long. You have 8 days left. So hurry up. If you are late, I will not extend it. And that is the thing, you can't extend it anyway. And that's how you work together. And so you are working on it. Sometime maybe one day late, you can bring some things to bear to show that you have to actually satisfy the requirement. And you will go along. But if you are the Attorney General or the public prosecutor is standing on the side against the court system, you are not an Attorney General. You should be removed, because it means the people you are going to work with, you have made all enemies. It will not work. It won't work. I'm sorry. But this man has done a lot of things, said a lot of things, all wrong, and he's still there. Why? For what? He's still there. He's the only one lawyer in this country to say, for example, that there's no evidence, there's no precedent of money laundering in this country, and therefore we don't have any case to go by to prosecute someone who's accused of that. What kind of nonsense is that? Precedent alone is what you use to prosecute the case? What about the first person who prosecuted the case? What precedent did he have? And we have precedents all around the world. Their thinking is flawed. That's what I say. I can say a whole lot more than that. But it shouldn't be there.
So back to my earlier question. You say he shouldn't be there. So is this a call from you, Dr. Bawon, the President, to relieve him of his duty as Attorney General and Minister for Justice?
For what I've seen so far, yes, I would say that. For what I've seen so far, I'll say that. Attorney General who cannot articulate to the country why students' papers that have been marked is not allowed to be seen by the very students. What kind of nonsense is that? If he doesn't know, I'm telling him now. There's a case called prior restraint. That case speaks directly to the students' issue. And if the judge, not just the lawyers read that, they'll see that they are wrong. You cannot tell a student, he cannot look at his own paper that's been marked, because the teachers are what? Magicians, they are computers, automatic, they make no mistake. Well, can you go to any court to say such a thing? The thing is his. Why can't he say? You say no. And you, Attorney General, you're sitting there for this to go on. All this time. That alone demands him being removed. I'm saying it again. Prior restraint. That case about prior restraint. If they don't know, they should go and read the U.S. The war in Vietnam. They will see the case came to court and Supreme Court ruled prior restraint is almost always unconstitutional. He doesn't know that in undergraduate law school. What is wrong with him? So you people should tell him. It's a disgrace. He is not fit to be Attorney General. That's what I say.
Another leg of all of this has got to do with how we describe the courts when decisions go in our favor, and how we describe the courts when decisions do not go in our favor. Yesterday in Parliament, for example, the majority leader was cautioning the minority about how they describe the judiciary, because there have been times where the minority or the opposition have said the judiciary is unanimous FC, the judiciary is not credible, and other things, because they believe that certain cases have not gone their way. But in this case of the Court of Appeal ruling in their favor, they are praising the courts. Is this something that we should look at critically?
You see, lawyers must be taught how to comport themselves, whether you agree with a decision or not. You are free to choose the side. That's why what you say after that. Does it mean that the court should come and call you to make the decision for them when you say all sorts of negative things, derogatory things about the court? No. You can say, I don't agree with the court, or I respectfully disagree with the court. I think you should have done that, but they have made their decision, and we are going to look at it and decide what we should do next. Don't even say you are going to appeal right away, because after you look at it, you may see that there's no point appealing. Maybe you missed something. Somebody may know something, come and forget it. So don't put all your eggs out at once.
Right.
We are going to study.
Okay.
This is how you talk as a person of the court.
Yeah, but Doc, I also wanted you to look at, the commentary, that politicians run about our courts and the kind of words that they use about decisions of the courts. Of course, under the rule of law, under a democracy, we have freedom of speech. But in terms of how we describe the courts, and especially the kind of effect it can have on the following that these politicians have in terms of, the perception of their followers. How should politicians be conducting themselves in their commentary? I mean, apart from those who are lawyers that you've just spoken to, those who are politicians, how should they be doing their commentary about decisions of the courts, whether it goes in their favor or not?
They should be a bit circumspect. You see, they should follow the lawyers. They are all in the same boat, though. They don't see that if you denigrate the court, you are denigrating yourself, because they are the final arbiter. It's the final place you go to get justice. And if you are saying they are no good, what are you going there for? Why would you go? You have another court. And so don't say that. Yes, the decision they make sometimes may not be very sound. Sometimes you can see that this is not good at all. But don't say it in public, because you have to go there to get justice. And so I don't agree. I respectfully disagree with the court, but we abide by the decision and we are going to appeal it. Then that means when you appeal it, you are talking to other judges, and they may see it your way. But if you start insulting the previous judges, why should they listen to you? What is the ones you are going to listen to you now? You may do the same thing to them. And so we have to teach them, all of them, the parliamentarians and senior officers, all of them should see that. I don't remember ever any time I had any senior officer administration, any member of administration denigrating the court. No, never had it. After 30 years of being in the U.S. system, I never had that. You see, that is what should happen here. It's not everything you can use loose mouth talk, street talk to answer the question. No. Now, when you go back again, should they clobber you on the head? That's the question. I don't understand it. We should teach them better than this.
Very well. Dr. Richard Amakoba, always a pleasure speaking to you here on the Morning Star.
Thank you, Duncan.
Very well. Dr. Richard Amakoba is a political scientist speaking to us this morning here on the show, reacting to what we've been discussing since we began the Morning Star here on Star 103.5 FM. The Court of Appeal deciding that Dr. Kesi Latu-Forson and Richard Jakpa are free men. We'll take a short break here. When we return, there's still more to come here on the show. Stay tuned.